Town of Kiowa Island Board of Zoning Appeals. I'm Frank Cassidy, the board chair. In addition to myself, the members hearing your case today are Jay Lewis, Larry Rosenfeld, Morris Hannon, Lynn O'Leary, and Phil Adams. And here from staff are our planning director, John and Dan Vincent from our planning staff. And Boone Aiken is our legal counsel. Our case rulings from this and any BZA meeting are available for public review and inspection during normal business hours at the town hall. Since our meeting is being conducted virtually via Zoom, please be reminded that in order to obtain a clean and clear record for persons listening live, it's important that all participants not speak over one another. If you'd like to speak, please raise your hand. I'll recognize you and you can come to the mic. At this time, I'd like to explain to the public the workings of the BZA. The Board of Zoning Appeals is a quasi-judicial body established to interpret and grant relief from the zoning ordinance. The Board of Zoning Appeals has jurisdiction over three types of cases: appeals, variances, which is what we'll be considering today, and special exceptions. Appeals are heard regarding administrative actions or decisions by the zoning administrator or staff. Variances may be granted when strict application of the zoning ordinance would cause an unnecessary hardship. This board's actions must be based on specific standards as contained in SC Local Government Planning Enabling Act of 1994 and our town's zoning ordinance. Special exceptions allow the board to permit uses if certain conditions as contained in the zoning ordinance are met. A simple majority vote of the quorum present is required to grant a variance or to overturn the decision of the zoning administrator in an appeal or to grant a special exception. Because today's hearing is a public fact-finding meeting, we are in compliance with the Freedom of Information Act and SC Code 6-29-70. 15 days prior to this hearing, an announcement was printed in the Post and Courier, a sign was posted on or near the designated property, and a notice was mailed to the applicant or representative, to persons residents within 500 feet of the application, and to parties of interest. Persons, organizations, and the news media that have requested declaration of our meeting have also been notified. These are the only folks who are required to be served under the Freedom of Information Act. Our purpose today is for interested parties to be heard in order to assist the board in gathering evidence pertinent to the case. If members of the BZA feel the need for further information to clarify a case, the board has the authority to subpoena witnesses. In addition to testimony, our board has been presented written information submitted to the staff by the applicant or their agent for each case. This information is now considered to be evidence and is entered into the permanent record of this body. It's assumed that it is complete, true, and accurate. Also, we've been presented data assembled by the staff for the purpose of clarifying the location and the effect on surrounding property. Our board is empowered to approve with conditions, or deny a request. In granting a variance, the Board of Zoning Appeals may attach to it such conditions regarding location, character, and other features of the proposed building, structure, or use as the board may consider advisable to protect established property values in the surrounding area or to promote the public health, safety, and general welfare. We are also authorized to defer a case should there be a need to obtain additional information. If an applicant's request is approved for a special exemption, a variance, or an appeal of a decision by the zoning administrator, they must go to the town of Kiowa Island to apply for permits. Variances and special exceptions granted by the BZA are valid for 12 months after this meeting. However, if an applicant's request is disapproved and they wish to appeal the decision of this board concerning their case, appeals must be addressed to the circuit court. SC Code 6-29-820 states that the appeal must be filed by the applicant within 30 days after the decision of the board is mailed to them. Failure to file an appeal within the time limit deprives the court of the jurisdiction to hear this matter. For the case, staff will present information, the applicant will present their case, and we'll hear from others, if any, who may wish to speak. Be reminded to direct your comments to the board, not to the applicant or other speakers. To expedite the meeting, I'd ask that all persons who intend to speak today to stand, and Boone will administer the oath.
All right. Good afternoon, everyone. If everyone could please raise your right hand. Do you promise the testimony that you are about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Great. Thank you, everyone. Mr. Chairman, I'll turn it back over.
I'll now call case BZA-24-000022 at 81 Bittern Court. First, we'll hear from staff, then the applicant, and then others, if any. All speakers should come to the podium, state your name and current address for the record before presenting testimony. I'll limit any comments by the public to 3 minutes, and the applicant will have a chance for rebuttal if necessary. Dan, the floor is yours.
Thank you, Mr. Chair. Members of the BZA, we have one case today, case number BZA 24-000022. The applicant and property owner, William and Ann Sherrill, being represented by Randy Rice of Rice Architecture, are requesting a variance for the reduction of the required 30-foot rear setback by approximately 86 square feet for proposed renovations of an existing single-family home. The lot 81 Bittern Court is located in the R1 residential zoning district. The lot size is approximately 24,556 square feet, or 0.57 acres in size. The TMS number for the subject property is 207-08-00045. Per Charleston County records, the lot was acquired by William and Ann Sherrill in May 15th of 2009, and the home was constructed in 1978 according to Charleston County records. Pursuant to the Town of Kiawah Island's Land Use Planning and Zoning Ordinance, the R1 residential zoning district does require a 25-foot front setback off of Bittern Court, a 15-foot side setbacks on either side, and a 30-foot rear setback. The maximum lot coverage for the subject property is 33%. Here's a zoning map of the subject property. The adjacent properties to the south, west, and across the lagoon are located in the R1 zoning district, and directly across from the subject property sits an R2O zoning district. Here is a Charleston County GIS aerial view. Staff took a few photos on November 27, 2024. Signs were posted in accordance to the Board of Zoning Appeals rules and procedures. And again, the request is for 86 square feet for proposed renovations. The picture of the front. Adjacent properties across the street and to the left. Here's the subject property, which is the rear. few more pictures of the rear side. The applicant's proposed plans include renovations of the existing single-family home, including relocating a staircase in the rear yard and converting an existing open deck into conditioned area that is currently beyond the rear setback. The home is currently non-conforming in regards to setbacks. As you can see on the slide in front of you, the left is an existing site plan. Portions of that site plan are encroaching into that rear setback. The existing staircase currently encroaches approximately 15 feet 9 inches into the required rear 30-foot setback. The distance from the existing staircase to the rear lot line is approximately 14 feet 3 inches. The total encroachment of the existing staircase is approximately 70 square feet. That existing staircase, if you can see my cursor, is this box right here. The proposed staircase, which is the gray area right here, it will be relocated further south and will encroach approximately 16 feet 1 inches into the required rear 30-foot setback. The distance from the proposed staircase to the rear lot line is approximately 13 feet 11 inches. The total encroachment of the proposed staircase is approximately 43 square feet. The proposed plans reduce the encroachment by approximately 28 square feet at this particular location. The existing open deck, which is south right here in this gray area, extends approximately 5 feet 5 inches into the required rear 30-foot setback. The proposed conditioned covered space will encroach approximately 5 feet into the required rear setback. The proposed renovation of the existing deck to screen porch is approximately 11 square feet. The proposed new conditioned area encroachment is approximately 33 square feet. The total square footage encroachment of the existing deck to conditioned or covered space is approximately 44 square feet. The total encroachment of both the staircase and conditioned area is approximately 86 square feet. The applicant's current total lot coverage is 24.3%, and the applicant's proposed plans include 7,283 square feet with a total proposed lot coverage of 29.7%. Subject property is allowed a maximum coverage of 33%. The BZA may grant a variance only if exceptional circumstances exist and where practical difficulty or uncertain or unnecessary hardship is so substantial, serious, and compelling that relaxation of the general restrictions ought to be granted. No variance shall be granted unless the applicant shall show and the BZA shall find that the following conditions are met. Criteria A, there are extraordinary and exceptional conditions pertaining to the particular piece of property. There may be extraordinary and exceptional conditions on this property. The unique shape of the lot and the orientation of the home on the lot are exceptional conditions. The home is also non-conforming in regards to setbacks. The lagoon is located roughly 52 feet from the required 30-foot rear setback. The space between the rear lot line and the lagoon provides additional screening for the home. Per the applicant's letter of intent, quote, "The lot is irregular in shape and heavily treed. The organic shape of the easement creates an additional condition of not having a rear lot line that is parallel to the rear of the house frame. And while the house does respond to the change in lot profile, the logical addition fits a 25-foot setback, much like the existing home. It is possible, due to the large number of trees throughout the site, that the home was simply located in the most tree-friendly location. And since moving the house closer to the large easement had only a positive effect on its neighbors, regardless, there is an extensive nonconformity that exists across much of the rear of this home, resulting in extraordinary and exceptional conditions. Criteria B, these conditions do not generally apply to other properties in the vicinity. These conditions may be unique to the subject property and may not generally apply to other properties in the vicinity. The property is located in the R1 zoning district. Adjacent properties along Bittern Court are also located in the R1 zoning district. The lot sits adjacent to a lagoon to the north and east. Properties across the lagoon are located in the R20 residential zoning district. Existing structures in the vicinity may or may not have similar encroachments based on these setback standards. Per the applicant's letter of intent, quote, in addition to a setback requirement of 30 feet to the property line, there is an additional 25 foot of drainage easement, high ground, before the lagoon actually begins, resulting in an expanse of around 50 feet along the back of the non-conforming structure. As it stands today from building to water. In the sense of the home does not abut a lagoon, but an easement. This would indicate a 25-foot to conditioned structure setback as a reasonable given to the accommodation that the easement already provides between the home and the lagoon. Criteria C, because these conditions, the application of this ordinance to the particular piece of property would effectively prohibit or unreasonably restrict the utilization of the property. The application of this ordinance to the subject property may not or unreasonably restrict the utilization of the property. Per the applicant's letter of intent, quote, the site location of the existing structure unreasonably restricts the utilization of the property without this variance. It seems clear that during the construction of the home, the ordinance in question was either not in effect or was not applied to this lot. And as the natural evolution of architecture over time to improve its quality and update its usefulness becomes impossible without this variance. Criteria D, the authorization of a variance will not be of substantial detriment to adjacent property or the public good, and the character of the zoning district or will not be harmed by the granting of this variance. The authorization of this variance may not be of substantial detriment to the adjacent properties or the public good. The existing buffer beyond the 30-foot rear setback is substantial. Per the applicant's letter of intent, quote, the authorization of this variance will not be a detriment to the adjacent property or to the public good, as the area in question is in the rear of the lot. Beside a heavily treed lagoon area and out of sight from all adjacent properties, the encroachment into the rear yard would not be any closer than it already exists. There is no substantial detriment to the public good, as the overall area of new impervious surface in the rear setback is minimal. Criteria E, Board of Zoning Appeals shall not grant a variance, the effect of which would be allow the establishment of a use not otherwise permitted in a zoning district to extend physically a non-conforming use of land or to change the zoning district boundaries shown in the official zoning map. Granting of this variance would not allow the establishment of a use not otherwise permitted in this zoning district, extend physically a non-conforming use of land, or change the zoning district boundaries. Per the applicant's letter of intent, quote, the variance, if granted, would not allow the establishment of a use not otherwise permitted in the zoning district. The current land use is conforming, and there would be no change to the zoning map with an approved variance. Criteria F, The fact that the property may be utilized more profitably should a variance be granted shall not be considered grounds for a variance. The BZA may not consider profitability when considering this variance request. Criteria G, the need for this variance shall not be the result of the applicant's own actions. The need for the variance may not be the result of the applicant's own actions. The subject property is legally non-conforming in regards to setbacks. Per the applicant's letter of intent, quote, there has been no work done on the existing lot. Criteria H, granting of this variance will not be contrary to the public or neighborhood interest, nor will not adversely affect other properties in the vicinity, nor interfere with the harmony, spirit, intent, and purposes of these regulations. Granting of this variance may not be contrary to the public or neighborhood interest, may not adversely affect other properties in the vicinity, nor interfere with the harmony, spirit, intent, or purposes of these regulations. Per the applicant's letter of intent, quote, there is no contrary effect to the public or neighborhood interest, nor will not adversely affect other properties in the vicinity, while being in harmony with the spirit, intent, and purposes of these regulations. And criteria I, granting of this variance does not substantially conflict with the comprehensive plan or the purposes of this ordinance. Granting of this variance may not substantially conflict with the comprehensive plan or the purposes of this ordinance. The Board of Zoning Appeals may approve with conditions, or deny case number BZA 24-000022 for the variance request for the reduction of the required 30-foot rear setback for approximately 86 square feet for proposed renovations of an existing single-family home at 81 Bitturn Court. Based on the BZA's finding of facts, unless additional information is deemed necessary to make an informed decision. Staff has not received any letters in regards to this case. And I would also like to point out a few things in the town's code in regards to uncovered stairs and at-grade patios. Pursuant to section 1264 in regards to setbacks, uncovered stairs or stair landings to building entrances may extend up to 5 feet into any required setback. Uncovered at-grade patios may extend into any required setback. However, they shall maintain a minimum 10-foot distance from the property line, and uncovered decks may extend up to 5 feet into any required rear yard setback. This concludes staff's presentation.
Thank you, Dan. I'll ask you, Dan, and I'll ask the applicant if you don't know, but this drainage easement, what is there, a pipe under there or something?
I'm not sure. I'll defer to the applicant for that. It's from the site visit, it just looked like an empty.
Yeah, it looks like nothing, so it's hard to understand what it's there for.
It looked like an empty kind of buffer area.
Okay, thank you. Any other questions for Dan?
Yeah, I have one. The proposed renovation, the closest point of the proposed renovation to the setback line looks like it's about 13 feet and change. What's the closest point currently? I take it it's the existing staircase. How far is that from the setback line?
So from what staff saw, the existing staircase encroaches 15 feet 9 inches into that required rear setback, which is about 14 feet and 3 inches from staircase.
So the proposal would actually be further from the setback line. Its closest point would be further from the setback line than is currently the case.
That's correct.
Other questions? Okay, we'll hear from the applicant. Is it Mr. Rice, is it?
Thank you, everybody, and happy holidays. My name is Randy Randolph Rice. I'm at 4250 Hope Plantation Drive, Johns Island, South Carolina. and I'm with Rice Architecture Plus Interiors. Our client has owned this property for a while, and it's been a great place for them. They've experienced Kiowa from this property, and it's just gotten tired. And so this effort is to redo the decks, redo the exterior finishes. In the course, you'll see the addition basically allows the guest room to have 2 ensuite guest rooms instead of 1 bathroom that's shared. So just sort of trying to bring the home up to the level of current amenities on Kiowa, if you will. There is as we've discussed, there's the new condition wing off the bottom back right, if you will. That's part of that bedroom ensuite approach. Instead of having an open deck that's getting covered with leaves, it's going to be a covered deck, so it's much more effective and usable. And the rear stairs, we took care to take the landing area of that stair, anything over 1.5 feet, if you will, to keep that above grade, to keep that as far away as the original stair was from the property line. And the covered deck that's there currently, perhaps that's the most covered, most encroaching area. That's at 18.4 off the current property line. And there's a deck above that area that is part of the renovation on the second floor, which doesn't pertain to you all, but that would be enclosed. So there's not an open second level deck, which got all the leaves for the last however many years for that house. It created a lot of drainage problems. So I think our case is fairly straightforward. As you can imagine, the house was designed and built prior to these regulations. And so they built it where it made sense at the time to them. And over time, the regulations made sense to apply over these properties. And so our clients caught between sort of a rock and a hard place. We have good, valid regulations, but we have a house that had no control over those regulations, if you will. And so now they're here to try to get a variance to try to kind of fill in that little gap where you've got an older home that really has sort of a fairly specific way it could expand, and it's going to require variance to do it. And with that, I'll leave that for any questions.
Thank you, Mr. Rice. Questions for Mr. Rice?
Was your question answered, or did he not know the answer?
He indicated that he doesn't know the answer either.
Oh, in terms of why there's that drainage area behind the house?
Yeah.
Is there structure under? I didn't come across any reason why they have that. One of my arguments about this variance was that technically this, that 30-foot setback is for lagoon properties. And technically, that part of the property is not next to the lagoon. It's next to this this easement, which would require a 25-foot, setback. So part of the argument, I don't want to really go down there, but really seems like it ought to have a 25-foot rear yard setback. We still need a variance for these other items, so I don't think we need to go down that path. But just as we're looking at
The
it,
effective setback is way more than the actual property lines.
yes, sir. I went out there again today and just to stare, not being germane to what's functionally affecting the property, to the corner of the house right now, where the new stair is, if you will. There's a double column. From that column location to the lagoons is 46 feet. And then if taping again, not a surveyor, but taping from the estimated corner of the new house addition on the bottom corner there, it was going to be 50 plus, 52, 53 feet still to the bank. So none of what we're doing is getting closer to that bank. Stair being sort of the, certain kinds of projects with foundations and such make much more difference whether they're right next, getting closer to that bank. So we're keeping away from that.
Other questions? Nope. Hearing none, I'd entertain a motion.
Can I make the motion?
Sure.
Okay, completely out of character. I move that we approve this. Stop laughing, Lynn.
Thank you, Larry. Is there a second?
I'll second it.
I can throw in a couple of reasons if you care to. I mean, it's just so far away from the lagoon. The easement is irrational to me. The only thing I don't buy is criteria C, where allowing this expansion will effectively prohibit or unreasonably restrict utilization of the property. That's a crock, because they can use the property fine without ever doing that. But aside from the rest, as long as they don't touch some of those great trees back there, go right ahead. I see no reason, nobody's ever gonna see the, thing from any other place because of the forestation to the lot. It's basically a blinded, addition.
Just want to make sure I understood. You believe that it meets all the criteria?
Yes, and I do,
It has to meet all the criteria.
Has to meet
Has to
all,
be what?
has to meet all the criteria, so you have to take C off the table, like you were talking about. So,
Am I still allowed to make the motion even if I disagree with it? I think I can.
Yeah, I think you can too.
It just depends on what my vote may be, that's all.
I'll still second it.
Thank you, Morris.
Any further discussion?
I love bureaucracies. Plus the fact, my vision may have compromised my view.
Larry.
All right, with no further discussion, Jay?
Yes.
Larry, yes?
Yes?
Yes.
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 And yes, so motion is unanimous.
Good,
It's
write it down.
approved because of the effective setback due to the easement. Also, it's a small encroachment to start with, and as Larry pointed out, you stand back there, no one anywhere near that property is going to see anything because it's so well.
I've never seen so many trees on a property.
Yeah.
I was just like, oh, Lord.
So that concludes our work with this variance request. I'll just mention that we may or may not have a January meeting. John is waiting for some additional information. But let me remind you that in January and February, something that I tend to forget, our meetings are the fourth Monday instead of the third, because the third Mondays in January and February are holidays. John?
No, that was correct. The only note is that we will probably not have a January, based on what I just discussed with Daniel, that we may not have a case as an update for the January meeting. So typically, at the beginning of the year, we would do our review of the rules of procedures. Since that, we may just bring that to the February meeting opposed to having a meeting where there's no items to consider. So just stand by for the January date. If there is, we'll also have the rules of procedures for you to review annually like we typically do.
Okay, so we may have a January meeting, we're just not sure.
Yeah, I don't believe that we will, but more than likely we'll be at February for the rules of procedure.
Okay.
Yeah.
You have have you published the dates for the entire year?
Town council just approved that at their December meeting, so we'll get that circulated to you guys if you have not seen that for the January. Yeah.
Great. Anything else, John or Daniel? Okay, we stand adjourned then. Thank you, everyone, and Merry Christmas,
Merry
Happy
Christmas, Happy
Hanukkah, Happy New Year.
Put in the full season.